listening to The Liberty Beat, your daily source for liberty news and activist updates. Online at thelibertybeat.com. John Bush here with your Liberty Beat for February 22nd, 2013. Gold opened today at $1,571, silver at $28.70, and Bitcoin is trading at $31.24. Today's edition of the Liberty Beat is sponsored by Voice and Exit, a conference in Austin taking place March 9th, exploring social entrepreneurship and radical community. Tickets and information online at voiceandexit.com. And now the news. A U.S. senator has said an estimated 4,700 people, including some civilians, have been killed in the contentious bombing raids of America's secretive drone war. It was the first time a politician or any government representative had referred to a total number of fatalities in the drone strikes, which have been condemned by rights groups as extrajudicial assassinations. The toll from hundreds of drone-launched missile strikes against suspected al-Qaeda militants in Pakistan, Yemen, and elsewhere has remained a mystery as U.S. officials refuse to publicly discuss any details of the covert campaign. In 2008, President Barack Obama made statements regarding a, quote, civilian national security force. Since that day, many have been curious as to what President Obama had in mind when he made that statement. Representative Charles Rangel may have just given a bit of insight into what he meant when he introduced H.R. 748 last week. H.R. 748 would require all persons in the United States between the ages of 18 and 25 to perform national service. These persons in the United States would either serve the country as a member of uniformed services or as a civilian service. The civilian service could be served with a federal, state, or local government program. Local government programs include community-based organizations. An Illinois state representative has introduced the Internet Posting Removal Act, which was introduced February 13th by Illinois General Assembly veteran Ira Silverstein, a Democrat. Here's a summary of the bill. The act provides that a website administrator shall, upon request, remove any posted comments posted by an anonymous poster unless the anonymous poster agrees to attach his or her name to the post and confirm that his or her IP address, legal name, and home address are accurate. Privacy advocates are protesting the measure. Members of a task force proposing regulations for recreational marijuana in Colorado approved recommendations Tuesday that would allow for marijuana tourism but block out-of-state pot shop owners. Today's edition of the Liberty Beat is sponsored by Central Texas Gunworks, CHL courses and firearm sales, online at centraltexasgunworks.com, and by Brave New Books, free-thinking materials for free people since 2006, online at bravenewbookstore.com.
Okay, this is Randy Kelton here on a Friday night, the first day of March, 2013. It's hard to believe we're in the third month of the year already. My mother warned me about this. This is our 4-hour info marathon. I expect to have a guest on, but he may be an hour late. He may not be on till the second hour. Our phone lines are going to be open. It's going to be Dan Reel. Those of you who listen to us pretty often have heard Dan on before. And he's going to talk about foreclosure and the foreclosure laws as they relate to Connecticut. But while we're waiting for him to show up, I'm going to talk about the foreclosure laws as they relate to everybody. I am doing some presentations that I intend to use as audios on some of my websites. So tonight I'm going to do a presentation on what to do if you've received a notice of intent to foreclose. If you have received a notice of intent to foreclose or a notice of acceleration, there's any number of different named notices you can receive that amount to essentially the same thing, then time is close. Time is short. And you need to do something. For those of you who are not familiar with the process, and the one that we talk about relatively often on the show, is the only thing that will get the bank's attention that we have seen is a lawsuit. There are modification programs, specifically the HAMP program put out by President Obama. But as we discussed last Friday with Winston Wallace, the HAMP program is one major scam, and the banks use the process to force you into foreclosure. We may get to that on this show, but if not, we will talk about that on another show in more detail. But for now, we're going to talk about what to do if you have a impending foreclosure sale. There are a number of things you can do. If you haven't done anything concerning the foreclosure process as yet, there are a number of things you need to do simultaneously, and with the things we're going to talk about first, you can do relatively quickly, so they don't take long, so you can get these out. And the first thing you need to do is send out a number of letters. Whoever is attempting to foreclose on you, on that person, you should you should send them a debt validation letter. Often a debt validation letter, if you've received a notice of a foreclosure sale date, the debt validation letter will very often cause the bank to put off the date. And that is as it should be, because when a debt validation letter is filed, the lender is obligated by the Fair Debt Collections Practices Act at 15 U.S.C. 1692G. The Fair Debt Collections Practices Act is 15 U.S.C. 1692. And in paragraph G, it goes to debt validation. If someone sends you a presentment under the Uniform Commercial Code is defined as a demand for payment on a debt in United States dollars. If you're sent a demand for payment from anyone, you may dispute the debt with that person. And if you send them a letter stating that you dispute the debt and demand that the claimant prove up their claim, then the debt collector is required to cease all collection efforts until he has proved up the claim. So, if they're in the process of foreclosure and you file the debt validation letter, they're going to claim that in this case they are not debt collectors. But in fact, they are merely attempting to recover collateral. The courts across the country are split on these issues. Some say, yes, you are a debt collector. Some say, no, you're not a debt collector. For our purposes, we don't care which district we're in. We don't care what the court said. We're going to make the claim. And the issue that we've been making with the lawsuits that we've been helping people produce is that they are a debt collector until they show that they are not a debt collector. And we've helped people file suits under Fair Debt Collection Practices Act claiming that the person was a debt collector and demanding that they validate the debt. Well, they came back with a Rule 12 motion to dismiss failure to state a claim, alleging that they were not debt collectors, and therefore they did not fall under the Act. So the argument that we're making here is that in order to implement the intent of the legislature, and that intent was to prevent someone with no claim on a debt from attempting to collect on a debt. If you have a debt with GMAC, and I call you from Joe Blow Collections and tell you that, or send you a letter saying I'm collecting for GMAC and you need to send all your future payments to me. Well, I don't know who you are. If I send you the payments and you are not collecting for GMAC, the payments I send to you do not extinguish the debt. And that's in Uniform Commercial Code. So I need to be sure of who I'm dealing with. Now, these foreclosing agents are saying, well, we're not debt collectors. We fall under the exclusion written into the code for those that are simply retrieving collateral. Well, there's an exclusion, and I don't remember the exact statute for it at the moment. I think it's C or D. But it refers specifically to people who are doing repos. That's what the purpose of the statute was. If somebody's repossessing your car, they're not collecting a debt. If their primary business is repossession, and they don't come to you and say, pay me this much money or I'm going to tow your car, they're not even in a position to take any money from you. They're only coming out there to collect the car. They are not a debt collector. But the foreclosing agents are trying to squeeze in under that exclusion and saying, oh, we're not trying to collect money, we're just trying to recover the property. Well, in order to recover the property, you have to give a notice of intent to foreclose in the form of a notice of default and opportunity to cure. And we're saying that makes you a debt collector, because you're telling them either you pay me a certain amount in United States dollars or I will become a collateral recovery agent. So the argument we're making to the court is, even if the jurisdiction says that the debt collector, that the foreclosing agent falls under the exclusion, until such time as you prove that you are actually in that position, then you fall under. If someone could be excluded from proving up their position just by making the claim that they weren't a debt collector and not have to prove it up, then the statute requiring someone to prove up their position would have no force in effect. So we're saying they are a debt collector until they prove they're not. And in our suit, we stipulate that if they will prove up their position, we will dismiss this issue. Because what we're claiming is we don't know who the real holder is. And with all this robo-signing and securitization and transferring these notes and deeds of trust all over the place, we don't have clues to the real holder of the debt is. So we don't know who has actual authority to perform the foreclosure. And we're asking you to prove up your position. You send us a notice of default and opportunity to cure. We need to make sure that if we send the amount necessary to cure to you, that it actually will cure the debt, and we won't have somebody coming back next week trying to foreclose again. So the first thing you need to do is send a debt validation letter. And when they receive the debt validation letter, they're statutorily stopped from further collection until they answer. Well, they'll send you an answer, but it will be non-responsive. They will send you the original deed of trust and maybe the note if they got a copy of it. They won't send you the originals. They won't make originals available. So in order to address that, in the debt validation letter, we also asked or demand that they produce the note for inspection by the borrower. Now, that is governed by Uniform Commercial Code 3-501. And it says that when a creditor sends a presentment to a debtor and the debtor demands production of the original security instrument, the creditor must make the instrument available for inspection by the debtor. He does not have to give it to him. He just has to show it to him. If he fails to do so, the debtor may cease all payments without dishonor. Well, this creates statutory estoppel on two different fronts. And it will almost always stop the foreclosure, at least the first time. It takes them a little bit to get grouped. Once they've sent you this bogus answer, then they may go ahead and try to foreclose again. And when we come back from the break, we'll talk about what you can do in those circumstances. This is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. Our call-in number, 512-646-1984. Give us a call. Call lines are open. We'll be right back.
All the talk about gun grabbing got you down? How would you like to be the proud owner of a brand new AR-15? Then go to LogosRadioNetwork.com and enter the drawing to win a free Rock River AR-15, sponsored by Zombie Killers Ammo and Guns. Support Logos Radio Network by donating just $20 to their fundraiser, and you'll get your name entered into the drawing. Second place prize is a Spikes Tactical AR-15 lower receiver, sponsored by CentralTexasGunworks.com. Every $20 you donate will put your name in the hat. So increase your chances of winning by increasing your donation. Winners must be eligible to lawfully own and possess these items. Please visit LogosRadioNetwork.com for details. If you love all the liberty-minded programming on Logos Radio Network, contribute to the fundraiser and secure your chance to win a Rock River AR-15, sponsored by Zombie Killers Ammo and Guns. Like them on Facebook at Zombie Killers LLC. Contest ends February 28th. Are you being harassed by debt collectors with phone calls, letters, or even lawsuits? Stop debt collectors now with the Michael Miras proven method. Michael Miras has won 6 cases in federal court against debt collectors, and now you can win too. You'll get step-by-step instructions in plain English on how to win in court using federal civil rights statutes, what to do when contacted by phone, mail, or court summons, how to answer letters and phone calls, how to get debt collectors out of your credit report, how to turn the financial tables on them and make them pay you to go away. The Michael Miras proven method is the solution for how to stop debt collectors. Personal consultation is available as well. For more information, please visit ruleoflawradio.com and click on the blue Michael Miras banner, or email michaelmiras@yahoo.com. That's ruleoflawradio.com, or email michaelmiras@yahoo.com to learn how to stop debt collectors now.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
On the edge of a hole, inside a deep dark bowl. I'm always on the lookout for something to soothe my soul. So I sit back and I watch the evidence unfold, and I see justice is the goal. Yeah, we got to get back on course.
Okay, we're back. Randy Kelton, Rule of Law Radio, and we were talking about foreclosure and what to do if you have a notice of intent to foreclose. The first thing we addressed was a debt validation letter. And it's a good idea if you can, before the foreclosure occurs, to get a suit filed under Fair Debt Collections Practices Act. You go ahead and send in the debt validation letter and then file suit for the same purpose. File suit demanding that the person claiming authority to foreclose prove up their position. Prove that they are actually a bona fide agent for the true holder of the note. Now, this is a big problem for the banks. The bank may actually be, or whoever the alleged agent, alleged principal for the agent is, may actually be the true holder. The problem is in the last 13 years or so, after the repeal of the Glass-Steagall Act and the repeal of the prohibition against derivatives, it sort of unleashed the money changers on us, and they got themselves into such a glut of swallowing all of the equity of this country that they just didn't take care of business. They didn't take care of the bookkeeping very well, and they can't prove up their position. So when you file suit for this, we've done a bunch of them, and the courts, you have to understand, are absolutely, totally corrupt. They will dismiss your case no matter what, because the banks have money and power, and they can apply political pressure, and the federal judges are scoundrels. Maybe they can't help it. Maybe their position depends on them being dirty, rotten scoundrels. But in the end, they're dirty, rotten scoundrels, and they will rule against a pro se out of hand at every turn. But that's okay. We have things we can do as pro ses. And I say this regularly. The courts hate pro se litigants. They don't hate pro se litigants because pro se litigants file stupid pleadings. They like that part. Makes it easy to screw them around. They hate pro se litigants because every once in a while they run across the pro se from hell. The pro se who knows how to use his position as a pro se to beat them up big time and do it absolutely legal by their own law. As a pro se, you don't have to worry about this scoundrel judge pulling your bar card because you don't have one. Generally, you don't have to worry about him sanctioning you because, for the most part, those things that will get someone sanctioned only apply to lawyers. As long as you don't cuss the judge out and put on the appearance of civility, you'll have no way to sanction you. When you start filing judicial conduct complaints against him every time he squeaks, that he can do nothing about. If you file a judicial conduct complaint against the judge, and the judge says one word to you, that's obstruction of justice, tampering with a witness. That'll get him in trouble big time. Same with bar grievances against attorneys. Bar grievances make attorneys nuts because it dramatically increases their malpractice insurance. So these are things we can do to them as pro ses that lawyers can't do. If you have a lawyer, he can't do any of these things. If he does anything that judge don't like, that judge can jerk his bar card at their caprice. But you don't have to worry about that. And we will show you how to take some actions that will make up for a lot of these problems we have with corrupt judges. And I'm hoping that if we can get a lot of people doing this, that we can put enough pressure on these judges that they will stop pulling these shenanigans to get us to stop filing judicial conduct complaints against them. And anyway, once you file the suit, you can expect a Rule 12 motion to dismiss failure stated claim. And that's going to come, they got 21 days to file that answer. So if you're looking at foreclosure, and they generally have to give you 21 days notice, and they generally time it so it's exactly 21 days notice. So you file a federal lawsuit. Once you file the federal lawsuit, then if you have once you file the federal lawsuit, there's almost certainly they will stop the sale. Now, it does not statutorily stop the sale. And I have a lot of people ask me, what can I do to stop the sale? Well, legally, statutorily, the only thing you could do to actually legally prohibit the bank from foreclosing is to get a court order. The bank can foreclose even if they have absolutely no grounds whatsoever. Now, they can get problems for it later. You know, that's like, what can you do to stop somebody from running a red light? Well, you can't. He's driving a car, and if he wants to run a red light, he can run a red light. But you can arrest him, charge him a lot of money, give him a lot of grief later, and foreclosures like that. If the bank feels like it can foreclose, it's going to go ahead and go through this routine. However, once you sue them, the reality is that win, lose, or draw, and the bank expects to win in the end. Because courts are corrupt. Courts are going to rule against you out of hand at every turn. With the banks ruling against you out of hand at every turn, we can probably keep them in court for the next 4 or 5 years. That's the reality. So, once you file an action against them, if the bank goes ahead and forecloses and evicts you out of the property while the litigation's going on, nobody in their right mind would purchase that property because there will be a less pendants, and we'll show you how to file with less pendants. And so the property's going to sit empty. You can't insure empty property. And California just passed new stiff laws making it a felony if you have empty property and you don't maintain it. And they passed new laws where the cities are trying to take these properties by eminent domain because they constitute a hazard. Excuse me. So, once you sue them, now they have reasons that don't have anything to do with a statutory estoppel. They have practical reasons for not wanting you out of the property. And once you get that in, there are a number of things. Even if they try to go ahead and foreclose, we'll show you when we come back from the break. We will talk about a bunch of the things they can do, you can do, to keep the banks from selling the property. This is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Law Radio. It's just me here tonight on our 4-hour info marathon. Give us a call, 512-646-1984. We'll be right back.
Britain leads the world in public surveillance cameras, but now they've taken surveillance to a new low. I'm Dr. Catherine Albrecht, back to tell you the repulsive place those peeping Toms have invaded next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Britain is swimming in surveillance cameras. At last count, nearly 2 million of them were spying on law-abiding citizens. But the UK privacy group Big Brother Watch just revealed something I can only describe as disgusting. Cameras have been installed in bathrooms and changing rooms in schools across Britain. It's unclear who's watching the footage or what the schools do with the film. School officials claim they need these bathroom cams for security, but parents want to know who gave headmasters permission to film their children using toilets and taking showers. Shame on those schools for teaching kids the wrong lesson about safety. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
This is Building 7, a 47-story skyscraper that fell on the afternoon of September 11th.
The government says that fire brought it down. However, 1,500 architects and engineers concluded it was a controlled demolition.
Over 6,000 of my fellow service members have given their lives.
Thousands of my fellow first responders are dying.
I'm not a conspiracy theorist.
I'm a structural engineer.
I'm a New York City correctional.
I'm an Air Force pilot.
I'm a father who lost his son.
We're Americans, and we deserve the truth.
Go to rememberbuilding7.org today.
It is so enlightening to listen to 90.1 FM, but finding things on the internet isn't so easy, and neither is finding like-minded people to share it with.
Oh, well, I guess you haven't heard of Brave New Books then.
Brave New Books?
Yes, Brave New Books has all the books and DVDs you're looking for by authors like Alex Jones, Ron Paul, and G. Edward Griffin. They even stock Interfood, Berkey products, and Calvin soaps.
There's no way a place like that exists.
Go check it out for yourself. It's downtown at 1904 Guadalupe Street, just south of UT.
By UT, there's never anywhere to park down there.
Actually, they now offer a free hour of parking for paying customers at the 500 MLK parking facility, just behind the bookstore.
It does exist. But when are they open?
Monday through Saturday, 11 a.m. to 9 p.m. and 1 to 6 p.m. on Sundays. So give them a call at 512-480-2503 or check out their events page at bravenewbookstore.com.
You're listening to the Logos Radio Network at logosradionetwork.com.
Yeah, I got a warrant, and I'm gonna serve them to the head of government, them, prosecute them. Okay. No, sir. Citizens arrest for Mr. Bush. Citizens arrest for this thing. Well, I need a prosecutor to come and help me.
Okay, we are back. Randy Kelton, Rule Radio, our 4-hour info marathon. And when we went out, we were talking about what you can do if you have received a notice of intent to foreclose. And first thing you want to do is send out a debt validation letter. That will generally stop the sale. And if you get the sale stopped, you want a federal lawsuit in before they can set another sale date, and that will generally stop them, at least for the duration of the suit. And we'll talk about what you can do with the suit later. Next thing you need to do is go to the Registrar of Deeds and pull every document that has been filed in the county records for this property from the date on which you were granted a warranty deed to the property. You'll look for a deed of trust or a mortgage, depending on the state you're in. You'll look for an assignment substitute trustee, an appointment of note and deed of trust, or appointment of deed of trust or mortgage, or just an assignment of the deed of trust or mortgage. Sometimes it'll say both, sometimes it'll say one or the other. These are the primary documents you're looking for. And you may see a notice of default or a notice of appointment of a notice of intent to foreclose. Then look at the authentication, the notary. Documents filed in the county record are not self-authenticating. Since these documents are filed by someone who just comes down to the court and hands it to the court, or they send it by mail, someone has to sign the document for it to be valid. And what an authentication is the person must go before someone who is authorized to do this. Authorized or to verify that the person who is claiming to sign the document is in fact the person they claim to be. And essentially that's all the authentication is. The notary will authenticate that this person came before me and either I knew him personally or he identified himself by this method, and I made the determination that this person is who he says he is. Well, this is one of the biggest areas of fraud in the whole foreclosure issue. And it is absolutely the dumbest place. It's arrogance, but it's beyond arrogance. It's hubris. To file a document with a fraudulent authentication is a felony. And these guys are filing hundreds and hundreds of them. We'll get to robo-signers in a minute. If you remember back to the 60 Minutes program on robo-signers, a guy actually got on national television and bragged that he could sign Linda Green's name 380 something times a minute. I'm sorry, an hour. 1 hour was enough felonies to put him in a federal penitentiary for several lifetimes. This guy was no rocket scientist, but he could write fast. And the notaries, it's a relatively minor thing, and it's standard business procedure. But these guys are cranking out foreclosures so fast that having to wait for a notary or having to have a notary set across the table from you while you're signing these documents and take the time to fill out their ledger and have you sign the ledger, well, that's inconvenient, and it's not efficient. So these foreclosure mills would hire somebody at an entry-level position who didn't know squat, and then come to them and say, hey, we need a notary. If you want to be a notary, why, we'll pay for the application fee and for your bond, and we'll buy you all of the materials that you need, your stamp and your ledger, and we'll make you a notary. And they say, wonderful, I'll be a notary. So they get their notary. And then the company comes to them with a big stack of documents and says, here you go, we need you to sign all these documents. And generally this is a law firm, so if a lawyer tells them to do it, they have no reason to believe that it's not legal. Well, actually they do. The law on notaries makes it very clear that it's illegal. But if a lawyer tells them it's okay to do it, then they're acting on good faith, reliance on competent authority. At least they feel like they are. And they sign these stack of documents so that when the foreclosing agent needs a notarized document, he just pulls one off the shelf, fills it out. If what the notary is required to do in Texas and in a number of other states, not all states, they're required to keep a sequential ledger. Anybody here who's ever taken a document and had it notarized you will recognize the procedure. You sign your document in front of the notary after you've identified yourself to the notary, and then the notary will fill out some stuff on this ledger and turn it around, have you sign it, and now they have a fingerprint pad where they have you put your fingerprint on it, or thumbprint on it. And that's so that if there is a question about the authentication, the notary can prove up the authentication. Well, the first thing you need to do is pull every notary name off of every document that's been filed and send them a letter requesting a copy of their sequential ledger from the day before to the day after any authentication that appears in the record. And we suggest that you do not send it yourself, that you have someone you know send it. And be sure to send it certified mail. Anything that you cannot conclusively prove that you sent and was received will go in the trash. Now, that may not be right, but that works. So always send it certified mail, return receipt. You may get a response. We do on occasion. But we have never, I said response. I should have said you may get an answer, because we have received answers. We have not received an answer that was responsive. If you ever watched the lawyer shows, a lawyer asks a witness a question. The witness answers a question the lawyer didn't ask, and the lawyer objects. Witness is non-responsive. If they send you an answer and it is not the sequential ledger, or if the sequential ledger is incomplete, the answer is non-responsive. And so far we have yet to receive a single responsive answer. If you don't receive a responsive answer, you now have reason to believe that the authentication is invalid. Now, there is one particular notary that most people will have a question about, and that's the one on the deed of trust or the mortgage. When you signed that at closing, there was a notary sitting across the table from you as a rule. Not always. There's required to be, but that doesn't always happen. We hear sometimes of the lender coming to your house and sitting down at the table and you fill out all the documents. Well, that's not quite legal, because that deed of trust or mortgage must be authenticated, because that document is intended to be filed with the county registrar. And documents filed with the county registrar are not self-authenticating. They must be authenticated by a notary. We will pick this up on the other side. This is Randy Kelton, Deborah Stevens, Eddie Craig, Ruleville Radio. Our call-in number, 512-646-1984. Marie, I see you there. We will pick you up on the other side. We'll be right back.
Mr. President, members of Congress, you've been making a lot of noise about taking our guns away. But you might want to review history. 1835, Gonzales, Texas Territory. The authorities wanted to confiscate the big gun that protected that colony. You know what the people said? Come and take it. Because they were willing to fight for their freedom and their guns. So are we.
Come and take it if you want it. Come and take it if you think you can. Come and take it, but I warn you, you'll have to pry it from my cold dead hands. We want the freedom that God gave us, so you best not cross that line. If you want this gun, you gotta come through us and take it.
One shot at a time. Just like Gonzales, we're keeping our guns.
Are you the
plaintiff or defendant in a lawsuit? Win your case without an attorney with Jurisdictionary, the affordable, easy-to-understand 4-CD course that will show you how in 24 hours, step by step. If you have a lawyer, know what your lawyer should be doing. If you don't have a lawyer, know what you should do for yourself. Thousands have won with our step-by-step course, and now you can too. Jurisdictionary was created by a licensed attorney with 22 years of case-winning experience. Even if you're not in a lawsuit, you can learn what everyone should understand about the principles and practices that control our American courts. You'll receive our audio classroom, video seminar, tutorials, forms for civil cases, pro se tactics, and much more. Please visit ruleoflawradio.com and click on the banner or call toll-free 866-LAW-EASY.
Okay, we are back. This is Randy Kelton, Rule of Law Radio, on our 4-hour info marathon, and we have a guest who's trying to get on, Dan from Connecticut. If you're listening, we don't have your Skype, so give us a call on the call-in page, and we'll bring you up. Okay, before I go back to the foreclosure issue, we have a call. Marie in Texas. Marie, what do you have for us tonight?
Can you hear me okay?
Yes, I can.
Okay, great. Thank you for taking my call. I was just wondering, I got a ticket recently, pedestrian and roadway ticket, and I was trying to...
Wait a minute, hold on. We are getting some serious 60-cycle hum.
Okay.
Are you on a headset?
No.
Are you on a speakerphone?
No.
Then you might turn your sound, your speakers down a little bit. You may be getting feedback from the speakers back into the microphone.
How's that? Does that sound better?
No, when you're speaking, there must be a issue with your mic. Go ahead, we can hear you.
Thank you. I got a ticket for pedestrian and roadway. Is there anything that I can do to not pay a fine on that?
Wait a minute, I missed a little bit of that. Did you say road rage?
A roadway.
Okay, say that again. I didn't get all of it.
I got a ticket recently for pedestrian in the roadway, W-A-Y.
Oh, jaywalking?
Not that. I was crossing the street, not at the proper crosswalk section.
Okay, is this Austin?
Yes.
Okay, this is probably better for Monday nights because I'm not particularly acquainted with the Austin statutes. But generally, jaywalking is a municipal ordinance, and there has to be one. They can't just say, they can't just charge you with that unless there's a specific statute. Does your ticket name a statute?
Well, they did give me a ticket, and they said they had a zero policy now because of some recent deaths or something, which I haven't heard about. But
okay, wait a minute. I'm sorry. Can you try calling back? I'm not able to understand you. That hum is getting louder.
So thank you. Bye-bye.
Okay. when we went out, we were talking about sending letters to notaries. And the one we were specifically talking about was the notary on the mortgage or deed of trust. Now, that notary was sitting right across the table from you when you signed the note, or at least he should have been. If there was no notary at the time, that's something we'll talk about on another show. We won't have time to get to that today, but that would go to declaratory judgment, because the property code is very clear that a claim, a document affecting a claim against real property, in order to be properly filed in the registrar's office, must be authenticated or proven. And if there was no notary, then the document is not authenticated. But if there was a notary, was that a notary? You don't really know. They look like notaries and they act like notaries, but what we have found in sending these letters out is they're not necessarily notaries. Or even if they were notaries, often they're not notaries any longer. And when a notary ceases to be a notary, the notary is required to send their sequential ledger to the clerk of the court, to the county clerk. We've never found a county clerk who had one. So, and what we have found quite often, more often than I would have expected, is that we send a request to the notary on the deed of trust, and we get a letter back saying the letter's undeliverable, so we contact Secretary of State, who oversees notaries and who issues the notary authority, and ask the Secretary of State for an address on the notary, and the Secretary of State says, we don't know who this person is. Now, we're not exactly sure what is going on there. It may be that once a notary has, their commission has expired and it hasn't been renewed, the Secretary of State may not maintain information on them. We don't know if that's the case or not, or if the Secretary of State never had any information on the person. We don't know what the deal is. But what we do know is the Secretary of State says to us, we don't know anything about this person. They're not a notary. We don't have any record of them. And for us, that works great. We can handle that, because that creates a adverse inference that whoever sat across from us at that table posing as a notary was not, in fact, a notary. Now, maybe they were, but there is no evidence to indicate that. So we can go back to the court and say, we have reason to believe, and we do believe, that this document was never properly authenticated, that the acknowledgement on the document was fraudulent, and ask that the document be stricken. And what the court's likely to come back and say, well, did you sign it? Objection. Relevance. It's irrelevant because the document must be authenticated or proven. And it is not. We don't know if that is precisely the document that we signed. They may have made up another one. So we can never know what that one is, unless somebody brings us the original, and they'll never do that. But we raise the issue, if we can get the deed of trust adjudged to be void and of no force and effect, the bank has themselves a big problem. But generally the one we can go after is not the deed of trust or mortgage. In this particular regard, there are other places to go after the validity of the mortgage or deed of trust. And we'll talk about that on another show. But that's not the one we generally go after. The ones we're really looking for are the assignments of substitute trustee and assignment of deed of trust. That one, we don't know who signed that thing. And this is the issue that goes to robo-signers. Problem with going to the court and accusing someone of being a robo-signer is you can go to the judge and say, well, Judge, this guy's a robo-signer. His name's splattered all over the Internet. And the judge is going to say, so? What does that have to do with this issue? Just because he's accused of being a robo-signer doesn't mean he didn't have authority to sign this document. What evidence do you have to show that he didn't have authority to sign this document? You say, well, Your Honor, this guy's a robo-signer. His name's splattered all over the Internet. So we sent a letter to the company for whom this person acted as an agent and requested evidence of power of attorney for this person. On these letters, we have never received a responsive answer. So now we can go to the court and say, Your Honor, we think this guy's a robo-signer. His name's splattered all over the Internet. So we sent a letter to the company for whom he signed asking for power of attorney. We didn't get any response. That creates the adverse inference that the guy did not have power of attorney. And we looked in the county record and expected to find evidence of power of attorney, as is required of anyone who files this type of document that is specifically referenced by Texas Probate Code 489. The legislature stipulated that anyone who files this type of document, it lists all the documents that are allowed to be filed with the county registrar. They must have, if they are signing as an agent for another entity or person or entity, they must have evidence of power of attorney filed in the record. But we didn't find any such evidence. So, creates prima facie case for this document being insufficient for filing in the record, and asks the court to rule that it's insufficient and is therefore void of no force and effect. And that's all we want the judge to rule on. And this is when we file a petition for declaratory judgment. We don't ask for any damages. We only ask the judge to make a declaration. And the only declaration we want the judge to make is that this document, as it exists by looking at the four corners, is insufficient for filing. We'll get to why a little bit later. Okay, this is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Our Radio. Our call-in number, 512-646-1984. We'll be right back on the other side.
Would you like to make more definite progress in your walk with God? Bibles for America is offering a free study Bible and a set of free Christian books that can really help. The New Testament Recovery Version is one of the most comprehensive study Bibles available today. It's an accurate translation, and it contains thousands of footnotes that will help you to know God and to know the meaning of life. The free books are a 3-volume set called Basic Elements of the Christian Life. Chapter by chapter, Basic Elements of the Christian Life clearly presents God's plan of salvation, growing in Christ, and how to build up the church. To order your free New Testament Recovery Version and Basic Elements of the Christian Life, call Bibles for America toll-free at 888-551-0102. That's 888-551-0102. Or visit us online at bfa.org.
Live Free Speech Radio, LogosRadioNetwork.com.
listening to the Liberty Beat, your daily source for liberty news and activist updates. Online at thelibertybeat.com. John Bush here with your Liberty Beat for February 22nd, 2013. Gold opened today at $1,571. Silver at $28.70. And Bitcoin is trading at $31.24. Today's edition of the Liberty Beat is sponsored by Voice and Exit, a conference in Austin taking place March 9th exploring social entrepreneurship and radical community. Tickets and information online at voiceandexit.com. And now the news. A U.S. senator has said an estimated 4,700 people, including some civilians, have been killed in the contentious bombing raids of America's secretive drone war. It was the first time a politician or any government representative had referred to a total number of fatalities in the drone strikes, which have been condemned by rights groups as extrajudicial assassinations. The toll from hundreds of drone-launched missile strikes against suspected al-Qaeda militants in Pakistan, Yemen, and elsewhere has remained a mystery as U.S. officials refuse to publicly discuss any details of the covert campaign. In 2008, President Barack Obama made statements regarding a, quote, civilian national security force. Since that day, many have been curious as to what President Obama had in mind when he made that statement. Representative Charles Rangel may have just given a bit of insight into what he meant when he introduced H.R. 748 last week. H.R. 748 would require all persons in the United States between the ages of 18 and 25 to perform national service. These persons in the United States would either serve the country as a member of uniformed services or as a civilian service. The civilian service could be served with a federal, state, or local government program. Local government programs include community-based organizations. An Illinois state representative has introduced the Internet Posting Removal Act, which was introduced February 13th by Illinois General Assembly veteran Ira Silverstein, a Democrat. Here's a summary of the bill. The act provides that a website administrator shall, upon request, remove any posted comments posted by an anonymous poster unless the anonymous poster agrees to attach his or her name to the post and confirm that his or her IP address, legal name, and home address are accurate. Privacy advocates are protesting the measure. Members of a task force proposing regulations for recreational marijuana in Colorado approved recommendations Tuesday that would allow for marijuana tourism but block out-of-state pot shop owners. Today's edition of the Liberty Beat is sponsored by Central Texas Gunworks, CHL courses and firearm sales, online at centraltexasgunworks.com, and by Brave New Books, free-thinking materials for free people since 2006, online at bravenewbookstore.com.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term rightly. I won't pay for the war with my body. Ain't gonna pay for their car with my money. I won't pay for the fun with my body. Their plans wicked and their logic shoddy. Ain't gonna pay for the oil with my body. I won't pay for the boys with my money. Ain't gonna pay for the kids with my body. The whole agenda sounds funny. I wanna fight in a war of my own. That one would be less accidental. I wanna pay for a war of my own. They live in glass houses so I can watch them grow old. I wanna fight in a war I can win. I can never win the one that they'd have me in. That one I lose long before it begins. I wanna pay for a war I can win when I'm fighting in my own war. It's such a peaceful feeling when I'm paying for my own war. I take time for the healing. Yeah.
Okay, we are back. Sorry for that delay, a little technical glitch on the break. We are back, and we are back with our very special guest, Mr. Dan Reel from Connecticut.
Greetings. It's good to be here.
Dan. Okay, I've done told everybody that you're going to give them all the answers to all of their questions about foreclosure issues.
Yes, except for the meaning of life, because I can't do that one.
Okay. Okay, talk to us about foreclosures in Connecticut.
Connecticut is a judicial state, which is obviously very distinct because in a judicial state they actually need to go to court, they need to file suit, and they basically need to get a judgment in order to take the property. Judgments in foreclosure in Connecticut come in one of two flavors. Their first flavor is strict foreclosure. That's basically when the debt alleged by the party foreclosing actually exceeds the equity you have in the property. The second flavor is foreclosure by sale. Usually what will happen in Connecticut is every possible chance the trial court gets, they will err on the side of having a foreclosure by sale. Does that make sense?
Well, it makes sense, just I'm not sure why.
Well, basically, that's just kind of an intro to the relief that a foreclosing bank would be seeking. The bottom line, as far as what I've seen, and most people in foreclosure, they're going to be dealing with what I would call fraud closure mills. In Connecticut, the big ones are Hunt, Liebert, Jacobson, and there's another one whose name that escapes me. It's Bendit and McHugh. Those are generally the big ones here. Down in Florida, I understand it used to be the law offices of David J. Stern, but believe it or not, they were actually shut down over a lot of the robo-signing issues. In one case, believe it or not, the trial court fined them $95,000 because they'd filed fraudulent documents. In Connecticut, and I know we were talking about this earlier, but the thing I should mention about Connecticut, and this is something we do agree on, is generally what will happen procedurally is the same in most states. And the first thing I think I really should talk about is the order of pleadings. Now, generally when you're in distress, you know it as a homeowner, and one thing I definitely should say to everybody is make absolutely sure that, obviously talk to an attorney, you have to say it, before you get in trouble, or talk to somebody before you get in trouble. And make sure you start collecting all those documents, like the letters you've received, any letters you may have sent, any emails, keep phone records, keep all of that down because you're going to need it later. But generally, what a fraud closure mill will do is first they will send you a letter saying, Dear Mr. and Mrs. Smith, your note is in default. Basically, you have 30 days to contact us, and if you dispute any, amount of this debt or any portion thereof, we'll obtain validation of it. The first thing they do is they will send you a letter. Generally, that is unless they've made some of the other mistakes I think that we're going to be talking about tonight. After that, you can generally expect some kind of a visit from a marshal. This is at least in Connecticut. And basically what will happen at that point is the marshal will show up with the writ, the summons, and the complaint. The complaint is obviously the complaint to foreclose your home. They're going to allege that you are so-and-so, you executed a note on such and such a date, you are in possession, of such and such a property, so on and so forth. Basically, there's this thing called the return date. And I want to explain this because, it's a finer point that I think a lot of people need to know. Because generally when people get into this and they generally call shows like this or they talk to anybody, they don't know what any of this is. So I think it's beneficial to discuss how this whole process starts. The return date, at least in Connecticut, again, it's going to be different everywhere, but the return date is the date that, the clock starts on the pleadings. In Connecticut, you have to have the complaint, the writ, the summons, and the complaint served at least 12 days before the return date. In Connecticut, the return date has to be a Tuesday. This is just the rule. Why Tuesday? I don't know. but that's what it is. And basically, 5 days in Connecticut after you serve the complaint, you have to file a form called an appearance, which basically says, I'm so-and-so, I'm, a defendant, I, have this interest, here's my address, and you have to send it to all parties of record. But if you don't appear in 5 days, believe it or not, most people don't even file an appearance in their foreclosure case, which usually means that the fraud closure mill is going to file what's called a motion for default for failure to appear. So the first rule of thumb is always respond to everything. Like you were saying earlier, always request validation. But above all, make sure you're on, time with all the pleadings and everything. But you have 5 days in Connecticut to appear. After that, you have 30 days beyond the return date to file a responsive pleading. Now, in Connecticut, and this is most likely the same everywhere else, the pleadings will work in this order. And by the way, if you don't file the first pleading or the second pleading in that order, you generally waive the right to file it with the exception of the motion to dismiss. The first pleading you can file is a motion to dismiss. Now, when you file a motion to dismiss, basically what you're doing is you're saying the court lacks subject matter jurisdiction. Now, the difference between a motion to dismiss filed at the first instant and later on in Connecticut is that in Connecticut, you have to file it right away if you want to say, hey, the process was insufficient. Hey, I wasn't served in time, like I got served on day 11 instead of day 12 before the return date, or something of that nature. But generally, a motion to dismiss can be filed at any time, but in Connecticut, the one exception to the rule is if you want to claim insufficiency of process or something of that nature, you have to file that right away. The second pleading that you can file is a request to revise the complaint. Generally, a request to revise the complaint is you're requesting that the other side revise their complaint because there's something scandalous in the complaint, which is highly unlikely with a foreclosure matter, but you never know, it could happen. Or that, a statement doesn't make sense, or it's not clear, or it's not legally sufficient. Now, the third pleading you can file is what's called a motion to strike. A motion to strike is used for, first of all, when there's a non-joinder of interested parties. I believe we're going to go into this, but obviously there are other people who may have filed like a lis pendens on the land records, or, there are other people who may have a claim on the property, but if they haven't been joined, you should probably file a motion to strike. Another reason to file a motion to strike is that the complaint is legally insufficient. It doesn't state facts that, if proven, would establish a cause of action or would entitle the party seeking foreclosure to the relief it seeks. Now, you can also use a motion to strike the request for relief claimed. For example, let's hypothetically say they're requesting a deficiency judgment, but in the complaint, they don't actually state facts that would support the award of a deficiency judgment. The next pleading you can file is the answer, which will include your special defenses and your counterclaims. An answer works very simply. In Connecticut and everywhere else, you have three options, and you have to go paragraph by paragraph. So for example, paragraph 1 of the complaint will say, and this could be any case, it would say, the plaintiff's name is John Smith, or the defendant's name is John Smith, or whatever. If it's not true, you say denied. That's all you do. If you want to admit to it, you say admit it. You could also aver that you don't have enough knowledge to form a good faith belief, which a lot of people don't do. Typically what will happen with a foreclosure complaint is, the foreclosure complaint will say, I executed a note on this date, and, of course the person's going to be like, of course I'm going to admit that. Of course, then again, with a lot of these notes today, do you really know? Do you really know that it's like, a bona fide contract or so on and so forth? But basically, you have to go through in your answer, and by the way, you don't have to file an answer right away. You can go through all those pleadings. But generally, if you don't avail yourself of the opportunity to file those earlier pleadings in that order, you generally waive your right. And you have to be very careful about this. Because a motion to strike, the first thing, obviously, you should do is collect all your documents and that. But the second thing you should do is go down to the land records. Make sure that, there's no other party interest, because if there is another party that has alleged an interest in the property and they weren't joined to the action, Well, obviously, you have non-joinder of essential parties, so you should file a motion to strike. That's just one example of why you should really be going through all of these steps. And, I mean, I hate to say this. Obviously, you shouldn't say it, but going through all of these steps as a matter of course will buy you time. And generally in Connecticut, you can ask for, you know, a request for an extension of time to file a responsive pleading. And generally, if you ask a lot of lawyers, what they will say is this is routine practice. They do it all the time. I've seen it as a defendant. I've seen it on the plaintiff side too. So don't feel afraid to ask more time to file a responsive pleading. But when you do, you should generally, you know, look for the rule and the rules of practice. Like in Connecticut, we have a Connecticut practice book. I think the new one for 2013, if it's not already out, is coming out soon. But what I would say to everybody is go download the latest rules of practice, because they will tell you the order of the pleadings and the reason you will file these pleadings. But in any case, I was mentioning this because a lot of people make the mistake of filing an answer right away. They will say, yes, I own this, I am in possession of this property. Yes, I executed this note. Yes, this is the bank. And basically, the next thing the bank will do if you get to that stage is they will move for summary judgment on the complaint. Now, when you move for summary judgment, you have to prove as the moving party that there are no material facts in dispute. Now, what is a material fact? Material fact is a fact that will actually...
All the talk about gun grabbing got you down? How would you like to be the proud owner of a brand new AR-15? Then go to LogosRadioNetwork.com and enter the drawing to win a free Rock River AR-15, sponsored by Zombie Killers Ammo and Guns. Support Logos Radio Network by donating just $20 to their fundraiser, and you'll get your name entered into the drawing. Second place prize is a Spikes Tactical AR-15 lower receiver, sponsored by CentralTexasGunworks.com. Every $20 you donate will put your name in the hat, so increase your chances of winning by increasing your donation. Winners must be eligible to lawfully own and possess these items. Please visit LogosRadioNetwork.com for details. If you love all the liberty-minded programming on Logos Radio Network, contribute to the fundraiser and secure your chance to win a Rock River AR-15, sponsored by Zombie Killers Ammo and Guns. Like them on Facebook at Zombie Killers LLC. Contest ends February 28th. At Capital Coin and Bullion, our mission is to be your preferred shopping destination by delivering excellent customer service and outstanding value at an affordable price. Capital Coin features a great selection of high-quality coins and precious metals. In addition to providing the best prices in the nation, we want to bring you the best shopping experience both in-store and online. In addition to coins and bullion, we carry popular longevity products such as Beyond Tangy Tangerine and Pollen Burst. We offer freeze-dried storable foods by Augustin Farms, Berkey Water Products, ammunition at 10% above wholesale, and more. You can lock in a spot price with our silver pool, and we set up metals IRA accounts. Call us at 512-646-6440 for more details. We're located at 7304 Burnett Road, Suite A, about a half mile south of Anderson. We're open Monday through Friday 10 to 6, Saturdays 10 to 2. Visit us at capitalcoinandbullion.com or call 512-646-6440.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick.
Okay, we are back. When we went out, I was so riveted with Dan's dialogue that I missed the bumper music. I get bumper music before you guys do. I can hear it. But I didn't hear it. I goofed. My bad. We were talking about an issue that is really subtle. And most people have a problem really wrapping their head around it. And that's the legal maxim that goes to never stipulate to anything. And when you respond to the pleading by saying, yeah, there's a note, yeah, they say they entered in this note, and you say, yeah, I entered in this note, well, you don't have to stipulate to anything. If they assert that you entered into a note, do not admit anything, make them prove it. Okay, go ahead, Dan. That was essentially where we were at.
Yeah, and the thing you have to bear in mind about it is, again, just to recap what I was saying, there are 3 ways to answer the numbered paragraphs in a complaint. You have to do this by numbered paragraph. You know, you can say admitted, you can say denied, or you can say, you know, the defendant doesn't have enough information to form, you know, good faith belief. I mean, there are other ways of saying that particular statement, but the bottom line is you're averring that you don't have enough information to say whether it's true or untrue. Now, when you go to your answer also includes special defense and or counterclaim. A special defense is a defense that's not the paragraph part of your answer, but it is nonetheless relevant and specific enough to the complaint to basically say, look, I have a special defense to this foreclosure action. Now, what are the typical traditional ones? Obviously, the first one is payment. I mean, payment would be a special defense. Look, yes, I had this note, but I paid it. Or somebody else paid it. Maybe, you know, an insurance paid it. Because believe it or not, I think a lot of people listening to this know this already. But generally, when a lot of these mortgages were created, they were not only designed to fail, but they were insured against that failure. It's analogous to the banks walking into an old folks' home and pointing to everybody in there and saying, oh, this is a 45-year-old male. He's never smoked a day in his life, and he runs around the track at dawn. Little does the insurance company know that it's a 95-year-old woman, and she cracked her hip 5 times. She has cancer, and she just got pneumonia. I mean, it really is that egregious, and that's something you can kind of walk into when you start filing your discovery requests. But in any event, a special defense is something you can plead that says, look, you know, I have a defense that isn't consistent with the allegations made, but nonetheless, it is a valid defense. Now, another defense, of course, is, you know, unclean hands in Connecticut. Because in Connecticut, and I believe this is the case in most other judicial states, but foreclosure actions in Connecticut are generally held as equitable actions. And the clean hands doctrine dictates that if you're going to come to the court and you're going to say, I want equitable relief, you have to show the court that your conduct has been fair, it has been forthright, and it has been honest, and it has been, you know, just straight up. Like, you know, you gave the other side notice, you know, you didn't try to trick the other side. And I'll give you a common example of that. Basically, a lot of these banks, you know, people will get a letter from one of the fraud closure mills. They will immediately put their brown pants on because they don't want anybody else to see what they're doing underneath. And they will say, oh, well, what am I going to do? And, of course, they're going to call the law firm, and the law firm is going to be like, why don't you sign this, you know, modification agreement? Why don't you submit paperwork to get a mod? And when people do that, there are 2 things that happen generally. The first is the proposed modification agreement. You agree to not sue the ever-living bejesus out of the bank for the fraud they committed and everything they did wrong, or for quiet title, or for anything. The second thing that happens is it creates this belief in the homeowner that, well, I'm applying for a mod. I don't have to do anything whatsoever. I don't have to file an appearance. I don't have to file, a responsive pleading. Well, guess what? That's always wrong. Because what they do in Connecticut, this practice actually has a name among attorneys that specialize in foreclosure defense. It's called dual tracking. Basically, the homeowner will be in a mod, and the law firm will continue filing the pleadings and all that other stuff on the other end of the case. So one special defense that, a lot of people can raise and they should really explore is, the clean hands doctrine. Again, it's probably going to be called something different according to your own case law, but that is one special defense. Another special defense that's actually been adopted by trial courts in Connecticut is the Connecticut Unfair Trade Practices Act. And believe it or not, it's a mirror of the federal statute. I believe the name of it is called the Federal Unfair Trade Practices Act, but basically, if a business engages in conduct that is immoral, unscrupulous or is designed to injure other, competition or consumers, it's generally considered a violation of CUTPA in Connecticut. Now, there's a lot of case law on this, but if you want to understand what a violation of CUTPA is, look up what the U.S. Supreme Court has called, they called it the cigarette rule. Obviously, cigarettes are very harmful, and, it's led to a lot of semblance, but believe it or not, it's modeled by the different marketing and selling tactics of tobacco, of all things. Now, this has actually been recognized as a defense to foreclosure. So those are just two examples of special defenses, but when you file your answer, you also have to file your special defenses. Counterclaims. Put very simply, a counterclaim is a claim that you would have against the party bringing suit. For example, let's hypothetically say, and of course this might go to a special defense as well, but let's hypothetically say you got that letter from that bank and you sent them a debt validation request. And instead of validating the debt or doing anything with it, they filed suit. I hate to stop here, but do we have like a minute or two before the bumper music comes back on?
Yeah, we've got 3 minutes.
We got 3 minutes. Excellent. But essentially, an example of a counterclaim would be like, let's just say they violated FDCPA in this entire process. You would make that a counterclaim. Or let's just hypothetically say, they violated RESPA, HOPA, or TILA just, for yucks. That would be a counterclaim you could file. So essentially, your answer, has to come with any special defenses you would allege and any counterclaims you would make. After you go through that pleading, this is when the tables turn on the plaintiff. The plaintiff can actually file a request to revise. They can basically file a request to revise any of your special defenses, counterclaims, or your answer. After that, they can file a motion for strike if they so choose. Generally, they don't do either one of those two things. But after the plaintiff can file its motion to strike, then the plaintiff has to respond to the special defenses that you allege, and they have to answer the counterclaim. And if they don't, they can be defaulted for failing to plead in the time required. Now, anybody at home listening to this can go to Connecticut Practice Book 10-8 and 10-6. 10-6 actually lays this order right out in a very concise form. It's easy to read. Don't be intimidated by the fact that the practice book has over 600 pages. It's very easy to find. Connecticut made this very simple to look up. And if there's one thing I definitely should say, it's not like the rules of procedure or the statutes are hidden away somewhere in a cave or something where you can't possibly look them up. Another thing I would say to people, law libraries are usually in most courts. I know the judicial districts in Connecticut actually have a law library in each one of them. You can pull up pleadings from any case if you go to the law library, and you can actually look up, different decisions. They have a lot of secondary legal sources, and I do want to talk about secondary legal sources, rules of practice, statutes, and case law when we do come back on the other side, because it's very important to understand. Because a lot of people, they'll just go into court and, they'll basically say, this ain't right. And the judge is going to be sitting there going, and, give me some authority or give me some set of facts that fit that specific authority, saying, give me the relief you're asking for.
Yeah, this goes to never make a proactive statement of law out of your own mouth. You must make proactive statements of law out of the mouth of the legislature or the courts.
And you have to establish facts on the record, which I think before we even go into that, I should probably talk about establishing facts on the record, because this is so very important.
Okay,
a lot of people don't.
Okay, on that note, we will go to break. We will be back on the other side talking about how to get facts on the record. This is Randy Kelton, Deborah Stevens, Eddie Craig, Rule of Our Radio. Our call-in number, 512-646-1984. We'll be right back.
Get out a hat and and sunglasses. In San Diego, law enforcement agents are using video surveillance cameras and facial recognition to pick faces out of crowds. I'm Dr. Catherine Albrecht, back with details in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights. Say no to surveillance and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Privacy-invading technologies are coming online faster than you can scream Big Brother, and one California company called Face First tops my spooky list. Face First has developed scanners that can sweep a crowd from 100 feet away to record every face and feed those images into a database. People are identified in under a second. Already deployed in Panama, Face First is now being tested on San Diego streets. Imagine the feds, drones, marketers, and stalkers all scanning our faces and identifying us as we walk down the street. Yikes, I'm buying a floppy hat and some sunglasses. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
A Noble Lie, Oklahoma City, 1995, will change forever the way you look at the true nature of terrorism.
Based on the damage pattern to the building, what the government says is impossible.
The grand jury did not want to hear anything I had to say.
The decision was made not to pursue any more of those individuals.
Some of these columns were ripped up, shredded, tossed around.
The people that did the things they did knew doggone well what they were doing.
Expose the cover-up now at ANobleLie.com.
At HempUSA.org, we offer chemical-free products to people around the world, detoxifying, self-healing, while rebuilding the immune system. We urge our listeners to please consider our largest-selling product, Micro Plant Powder. Our Micro Plant Powder is rich in iodine, probiotics, zinc, and silica to help rebuild the immune system and to create a healthy stomach flora. Micro Plant Powder is excellent for daily intake and is perfect to add to your storage shelter. We urge our listeners to please visit us at HempUSA.org. And remember, all of our products are chemical-free and healthy to eat. We constantly strive to give you the best service, highest quality, and rapid shipping anywhere. And we offer free shipping on orders over $95 in the U.S. Please visit us at HempUSA.org or call 908-691-2608. That's 908-691-2608. See what our powder, seeds, and oil can do for you at HempUSA.org.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. This is Randy Kelton with our special guest, Dan Reel. And when we went out, we were talking about getting your facts straight. Straight on the record. Go ahead, Dan.
Yeah, you basically, you have to, I don't care what it is you're asking for. I don't care if you're asking the case to be dismissed. I don't care if you're asking for, some kind of relief related to the case. You just have to first, before you even ask for anything, before you even do anything, forget what you're trying to do. You have to realize that in court, you have to put your facts on the record. Now, there are two ways this generally occurs. One, it's in the pleadings. It's generally in a form of an exhibit. For example, if you say, look, I have this document here that conclusively says that the documents that the other side have don't mean anything. Now, I'm going to give you a real example of something I worked with. There is a company called Wells Fargo. You might have heard of these fine folks who are awesome human beings. They just want the best for mankind. and they want to deal fairly with people. Okay, I lied about that. But there's another company called American Home Mortgage Servicing Incorporated. Now, the funny thing is AMSI for short. I mean, it's just easier to say AMSI. AMSI, what they will do is they will file documents assigning mortgages. They will create affidavits. They'll do all this other work related to the foreclosure process. And basically, the documents are obviously not authentic. There are a lot of problems with the people allegedly signing for them. So the long story short is, these documents are no good, and we have to prove that they're no good. When they come into court on behalf of Wells Fargo, what they're going to say is these documents are legitimate. Believe it or not, real life example, in one case, we put an 88-page civil complaint filed in the state of Texas where Wells Fargo sued AMSI, and they basically said, these documents are BS. They're signed by people that weren't authorized to sign them. They weren't properly notarized and all this other fun stuff. So basically, one thing you always want to look for if you're looking for evidence to put on the record in the form of a pleading, again, attach it as an exhibit, label as an exhibit, like Exhibit A, I've got the civil complaint here that says the documents presented by the other side are not genuine, they're not authentic, or whatever the case may be. But you always want to label your exhibits and your pleadings, and you will want to refer to them. A pleading will start out by setting forth the relevant facts to the pleading. For example, in a motion for summary judgment, you will set forth the following facts, like this complaint was filed on such and such a date, and it's for this relief, and here's our proof that there are no material facts in dispute. Fine. The second part of a pleading will generally go into what is the legal standard of review. That's where you're going to pick out your statutes. That's when you're going to pick out your case law. That's when you're going to pick out your rules of practice. That's when you're going to pick out your secondary legal sources. The first thing you always want to go to is, if you can, if there's a statute that applies to it, find that statute. And if the language is clear and it fits the facts, great. I always say, look, throw in some case law and support. What case law does is case law basically answers questions, or it deals with questions that have already been answered. So, for example, in Connecticut, and this goes to DUI cases, there is a question of what operating a motor vehicle meant. Forget the discussion on whether you're in commerce or whatever for a second. Just bear with me. Basically, the appellate court in Connecticut on that question, they said, look, there was this one case where the guy had the key in the ignition, his headlights were on, he fell asleep in a parking lot, he wasn't moving anywhere. The appellate court decided, well, clearly he's not operating the vehicle, he's not putting it in motion. The Supreme Court actually reversed it and said, look, he had the key in the ignition, he could have operated it, even though he was asleep, we don't care. So that's just kind of an example of different things. Although, granted, I disagree with this, but that's just an example of the different type of question you would want to be answering or asking. So basically that's what case law is for. That's when you cite case law, that's when you throw it in. Practice book sections. This is especially important if you have a question or you have relief that you're seeking that has to do with the rules of practice. For example, let's just hypothetically say you are sued and somebody's trying to foreclose your home, and you don't file an appearance, or you don't file a responsive pleading. Well, let's just take the responsive pleading part. The plaintiff would actually file a motion for default for failure to plead. They would say, look, here's the order of pleadings. It's in Practice Book 10-6. This guy did not file any pleadings. The time to plead is defined in Practice Book 10-8. Ergo, Your Honor, you should grant this motion to default for failure to plead. Now, I know there are a lot of judges who don't listen to people, but at the same time, you've got to bear several things in mind with that. First of all, you have to make it so crystal clear that it would be a nightmare on appeal for this trial court, because, believe it or not, a lot of judges hate being appealed, because that's their career. And in Connecticut, the trial court judges, they serve 8-year terms. So whenever they're up for renewal by the General Assembly, that's one of the things that is looked at. How many of your decisions were appealed? And of those decisions that were appealed, how many of them, were actually overturned? So that's one thing you have to bear in mind. Another thing you have to bear in mind is it's easy to say the courts are corrupt. I'm not even going to disagree there. However, bear in mind, both in your pleadings and when you speak before the court, that everybody only has so much of an attention span. So you always want to make your argument as short and as to the point as possible. Don't tell me how unfair it is. Don't tell me how much stress this has put your family through. Keep it relevant. So those are generally, two of the things you have to bear in mind, whether you're writing a pleading to set your record or whether you're speaking in court. Now, as far as making your record goes, the other way to make your record is depositions. You can actually call the other side or a witness with first-hand fact knowledge to be deposed at some place or some time. Admissions and interrogatories, I think we're going to have to get into those on the other side, but they're very important. So are requests for production, which are technically interrogatories, but again, we'll cover that later. The other thing is you can actually have witnesses for the other side subpoenaed, like Linda Green. Okay, well, Miss Linda Green has signed this document saying that the mortgage was sold to Wells Fargo or whoever the case may be. You can actually have Linda Green subpoenaed. Now, I think, as we know, there are a lot of different people who are Linda Green, which should make the other side pretty much have a cow and go, what are we doing here? But essentially, you have subpoenas as a means to, compel people to show up and testify. Of course, you can testify. Anybody who's there can testify. But long and short on testimony is with your questions, keep them short, keep them relevant, and build a foundation. You want to start out, like, let's just say, for example, you had a traffic ticket. Officer so-and-so, how long have you been on the force? Okay, yeah, and you'd get them talking. And, you would basically ask, well, have you been trained with a radar gun? How often do you train with a radar gun? Do you remember the serial number of the radar gun? Things of that nature, and you keep building it. And it's like, well, were you here on this day or whatever, according to what you said earlier. But with testimony, I mean, it's probably something for another show, but basically testimony works in this order. The first phase of testimony is the person who called the witness will examine the witness, okay? The second phase of testimony is cross-examination. During cross-examination, the other party gets to ask questions only about things that are either in the record that they would know about or based on the things they just said during direct examination. And then there's re-examination, where basically we start over, and the goal of re-examination is to basically get the person to clarify points that were raised earlier in the earlier two phases. Then there's re-cross-examination, which pretty much works the same way, except the other side is doing that. Does any of that make any sense?
A little bit. This sounds like Perry Mason. But yeah, one thing you forgot to mention, in direct testimony and direct examination, you cannot ask the witness a leading question. And with that note, we will go to break and we will pick up on leading questions when we come back on the other side. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. Our call-in lines are going to stay open. We should finish up this section soon.
It is so enlightening to listen to 90.1 FM, but finding things on the internet isn't so easy, and neither is finding like-minded people to share it with.
Oh, well, I guess you haven't heard of Brave New Books then.
Brave New Books?
Yes, Brave New Books has all the books and DVDs you're looking for by authors like Alex Jones, Ron Paul, and G. Edward Griffin. They even stock Interfood, Berkey products, and Calvin soaps.
There's no way a place like that exists.
Go check it out for yourself. It's downtown at 1904 Guadalupe Street, just south of UT.
By UT, there's never anywhere to park down there.
Actually, they now offer a free hour of parking for paying customers at the 500 MLK parking facility, just behind the bookstore.
It does exist. But when are they open?
Monday through Saturday, 11 a.m. to 9 p.m. and 1 to 6 p.m. on Sundays. So give them a call at 512-480-2503 or check out their events page at bravenewbookstore.com.
Are you the plaintiff or defendant in a lawsuit? Win your case without an attorney with Jurisdictionary, the affordable, easy-to-understand 4-CD course that will show you how in 24 hours, step by step. If you have a lawyer, know what your lawyer should be doing. If you don't have a lawyer, know what you should do for yourself. Thousands have won with our step-by-step course, and now you can too. Jurisdictionary was created by a licensed attorney with 22 years of case-winning experience. Even if you're not in a lawsuit, you can learn what everyone should understand about the principles and practices that control our American courts. You'll receive our audio classroom, video seminar, tutorials, forms for civil cases, pro se tactics, and much more. Please visit ruleoflawradio.com and click on the banner or call toll-free 866-LAW-EASY.
Well, you know karma's lurking around the corner. You better watch every step you take. It's good and pretty to follow you. Yeah, little Jerry, see reality. Okay, karma's lurking around the corner. Sing, Jerry, come.
As we so many crucial words get put on. Oh, how we see. Try as we will, turn small steps into giant leaps. What goes around comes around. As we sow, so shall we reap.
Listen to this song. Tell everybody, pass on the words of Almighty. Lend a helping hand, me say, as you go along. No lay karma, me say, knock you down, man. Carry the barn if you don't plant no seed.
Okay, we are back. Randy Kelton with our special guest, Dan Reel. Dan, you were going to tell us about leading questions, weren't you?
Yes, a leading question. You generally can't lead your own witness, which you did to me. That's an example. You were going to tell us about leading questions, weren't you? A leading question is that supposes the answer. For example, Mr. Smith, when you ran that red light over there, were you or were you not going 60 miles an hour? I mean, of course, if it's a red light ticket, I think everybody gets the point. Just briefly, some things you can't do, I don't care who you're asking the question to, is you can't have a compound question. A compound question, put simply, is two questions. Is your hair brown and do you have blue eyes? Is a compound question.
Yes, that'll draw the objection. Objection multifarious.
Yeah, of course, there are other things you can object to, objections to lines of questioning. I mean, for example, the question's argumentative. I mean, you're a rotten, dirty scoundrel, aren't you? I mean, objection, it's argumentative. But things of that nature. I mean, basically the whole point of this discussion was testimony is one way to get your evidence on the record. In between that and the pleadings, I believe the last thing that I wanted to mention, just briefly, of course, there are other ways to get things in. One of your most powerful tools, I don't care what you're talking about, are requests for admissions and interrogatories. Now, there's a difference between the two of them. A request for admission is basically a statement. You will say, first request for admission, Wells Fargo is a bank, admit or deny. You don't say admit or deny, but, that's the response. They will admit or they'll deny. Or they will file a written objection saying, well, this isn't relevant, this has nothing to do with finding or locating relevant evidence. And believe me, banks will love to do that. They will object just for the purpose of buying time. But requests for admissions fundamentally are designed to narrow the issues that are going to be covered in the litigation. Obviously, if you have a request for admission saying, there was a third party that made a payment on this note. Well, obviously, if they admit it, well, guess what? You've established a special defense of payment, and basically you've kind of narrowed that issue. No longer does it need to be discussed at trial. So you use requests for admissions to narrow the issues in the case. The second form of discovery that's very much important is interrogatories. Interrogatories, you can ask a question or you could demand production of something. For example, please produce copies of this notary public's book that, said, like, this guy, like, appeared before her and said, I am the vice president of J.P. Morgan Chase, so on and so forth. And, you can put subparts to different interrogatories, like, please give a reason for each answer. Please give, the name and address for service of, the person or persons preparing the answer to this. Something of that nature. You can ask a lot of good questions that way. But basically, interrogatories and requests for admissions, the answers to those can be admitted in court as evidence, and the other side has to either answer to them or object to them. Now, here's what you have to bear in mind about admissions and interrogatories. They may or may not necessarily become relevant unless something in the pleadings or something in the testimony has made them relevant. For example, let's just say you've only filed a motion to dismiss, you just filed your appearance, and the only thing on the record really is the plaintiff's complaint. Well, guess what? Your admissions, your interrogatories can only ask about that, can only ask about the facts alleged. However, if you do it later on, after special defenses have been filed, after your answer's in, after there's a counterclaim, well, then you get to ask about all that. One thing I can say is be very, very careful about the timing of when you employ these tools. Now, it's tempting to do it right away sometimes. And sometimes if you have other information, you could say, well, yeah, that's the reason I filed it. For example, if you're going to bring up the special defense of payment and you're going to say there was some insurance policy that kicked in and paid the note, and the other side objects, you say, well, we're looking to raise this as a special defense. Hopefully it flies. It probably won't. The second thing you have to bear in mind is that when you file these things, when you file your discovery request, generally, this way it is in Connecticut, it could be different elsewhere, you don't actually file a copy of your request with the court just yet. You actually file a notice that, oh, by the way, notice that plaintiff so-and-so has received my request for admissions or interrogatories. And then if there's a dispute, like if the other side objects and they don't want to answer and you have a dispute, generally what you have to do is you have to work with the other side and be like, listen, answer this. Is there some kind of agreement we can come into, or make a really compelling argument as to why they should answer it. And if you can't work out your discovery disputes with the other party, then you go to the court and say, listen, Your Honor, I tried to work this out. These guys just don't want to answer the question. Or they don't want to answer this, or they don't want to answer that. And when you do that, you have to tell the court it's relevant because of A, B, C, or D. You can't just say, I'd like to know what his wife wore last evening. You have to say, here's why it's relevant to the case. Here's where it came up. So basically, those are very powerful tools. And generally what I've seen with a lot of the fraud closure mills is once you start asking really annoying questions, the pleadings come to a stop. That is, provided you've filed a responsive pleading. Now, there are some cases I've seen where basically this stuff goes on hold for like a year or two or even 3. So once you start asking these really annoying questions, that you can come up with based on the different issues that even we just discussed today, a lot of banks are very hesitant to go forward because, A, they generally know what you're talking about, what you're looking for, and they are afraid of, different stuff that will come out. The other thing you have to bear in mind is the economics of a fraud closure mill. Bendit McHugh and Hunt Liebert Jacobson, they specialize in doing these very quickly, as in 4 months flat. Now, once you start asserting your rights, even if you do a haphazard, poor job of it, I mean, not that I emphasize being careless or screwing it up, because remember, this stuff is on the record for appeal. It generally messes up the whole economics of the machine. So the more they have to respond, the more they have to answer. I mean, it's not uncommon for them to hire another law firm to come in and basically be like, help us, this guy's fighting back. You know, and what I can tell you that after dozens and dozens of these things, that pattern has definitely emerged in my mind. So I think we are probably ready for some questions. I mean, as much as I'd like to go into the appellate stuff, I mean, this is pretty much what the show's for.
Okay, this really sounds interesting, and this is way too much information for me to absorb all at once. We may need you back again to go through this again. Frankly, I feel like I'm being educated, because you're going through a lot of things that I don't get to a lot. And you may turn out to be a resource for me to go to and ask the hard questions.
Well, it's your fault, Randy.
Well, it's always the most complimentary when I help someone get started, and then I get to go to them and ask them questions. For the master to become the student is, I find that as high praise indeed. And besides, I'm somewhat lazy, and I would rather somebody else do all the work.
Yeah, I only went to the Connecticut Supreme Court once.
Only once?
Only once.
Okay, I only tried to get the Chief Justice of the Supreme Court in Texas arrested once. So far, I'm still working on him. But it sounds like in Connecticut you may have a more responsive judicial system because of the way the foreclosure is structured. It doesn't seem as though it's quite so easy for the banks to just roll over someone who fights back. Have you found that to be the case?
I have definitely found that to be the case. I think probably the only better state is Massachusetts.
Well, we've had trouble with Massachusetts. The courts there seem very reluctant to rule for a pro se, even when the law is abundantly clear. And Massachusetts is probably the strangest state that I've looked at, because it's a mortgage state, it's a judicial state, but they can foreclose non-judicially.
Yeah, the one thing I can tell you about Connecticut is Connecticut, believe it or not, I mean, I'd probably say 4 years ago, you're SOL as a pro se, there's no hope, don't even try it. But now a lot of the judges are actually getting really curious. Like, there have been a few judges that...
Okay, wait, hold on. We're about to go to break. We'll pick up on the judges when we come back on the other side. Our call-in number, 512-646-1984. Rob, I see you there. We'll pick you up on the other side.
The Bible remains the most popular book in the world. Yet countless readers are frustrated because they struggle to understand it. Some new translations try to help by simplifying the text, but in the process can compromise the profound meaning of the Scripture. Enter the Recovery Version. First, this new translation is extremely faithful and accurate, but the real story is the more than 9,000 explanatory footnotes. Difficult and profound passages are opened up in a marvelous way, providing an entrance into the riches of the Word beyond which you've ever experienced before. Bibles for America would like to give you a free recovery version simply for the asking. This comprehensive yet compact study Bible is yours just by calling us toll-free at 1-888-551-0102 or by ordering online at freestudybible.com. That's freestudybible.com.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.